AT Law Call, the program that answers your legal questions live on the air. And joining me this week is attorney Rocky Wilkins. And tonight we're asking, can my boss do that?
That's right. You know, tonight we're discussing discrimination on the job. What are your rights at work? When can you be fired? Is there anything you can do if you're not getting the same pay and benefits as everyone else? If you're having trouble with your boss or your coworkers, or if your boss who's having trouble with your employees, give us a call. We'll take your questions live.
And the number to call, 601-965-7551. Again, the number is 601-965-7551. Stay with us. WLBT Law Call is next.
WLBT3 Law Call.
Welcome to Law Call, everyone. Each week we discuss a different legal topic and take your legal questions live on the air. Tonight, our topic, can my boss do that? The phone lines are open. If you have a question, give us a call at 601-965-7551. Again, that number, 601-965-7551. But before we go to the phone lines, let's see what's on the docket for the next few weeks. On September 3rd, we'll tell you the truth about trial lawyers. Then on September 11th, we'll talk about going to trial. September 18th, we'll discuss bankruptcy. So mark your calendars for all those great topics. And get your questions ready. You got plenty of time to start thinking about it, right?
The truth about trial lawyers, that one I want to see.
Me too.
Yeah, I can't wait.
I can't wait to see that.
What you been up to, Tamika?
I'm just really busy.
Yeah,
really
with the
busy.
Red Cross?
Red Cross, that's why I brought this pen, because
Yeah.
I wanted to make sure you can answer the question, are you Red Cross ready? Are you
Yeah,
ready?
I'm ready.
Do you have a plan?
No, but I'll get one right
you
after
have
the show.
You have a kit, you have a little kit. You got to get ready.
I have a
you
feeling
got that
you're gonna
beautiful
help me
little
get
son.
that
I'm
after
going to
the
help
show.
you. And everybody else at home, make sure your family's ready. I mean, we're watching these different storms come
Yeah.
through, but
Very
you never
serious.
know when anything's going to brew here.
That's right.
Mississippi's prone to it. And I'm just proud of all the volunteers. Red Cross volunteers are just really stepping up. And we have more than 25 already deployed, others on standby to leave the area. So we hope you all have a safe return. And
Well, you do a great job with the Red Cross,
Well,
and we
thank
appreciate
you.
your hard work.
All right.
Tonight we're going to talk about, can my boss do that?
Can my
It's
boss
always
do
a fun
that?
topic, and we have Nick Norris, who's a friend of mine. He's a lawyer with the Lewis Watson Jr. Law Firm here in Jackson. Nick, welcome to the show.
Thank you. Appreciate you inviting me.
And I'm going to tell everybody, Nick knows his stuff.
That's right.
I've been just asking little questions here and there, and
Yeah.
some of the stuff I didn't want to hear, but he's telling the truth today. So if you have a question, give him a call. The number is 601-965-7551. But real quick, before we take this first call, Nick, tell us a little bit about yourself.
Sure. I'm an associate with Lewis H. Watson Jr. PA. I've worked for him for 7 years. We handled quite a bit of employment claims. I would say 95% of our representatives are representing employees, our clients.
All right. Well, okay. Let's take our first call. You ready?
Yes.
Okay. We'll
Let's
talk
get started.
about Red Cross ready. Are you law call ready?
I think so.
All right.
We'll see.
Okay. Our first caller is Gloria from Jackson. Welcome to Law Call, Gloria. You can ask your question. Gloria?
Hello?
Hi.
Yes.
You can ask your question.
Okay, what rights do I have on my job security when I'm being, my hours are being, I'm being accused of things that I don't feel like I'm doing, and now they are not giving me proof on the situation, and my hours are being cut, and another person comes on job getting more hours. Can they fire me? I worry about my job security. My job performance is excellent. I have not got any bad marks or anything on my job performance. It's outstanding. My question is, what are my rights?
Sure.
Or what can I do concerning this?
Sure. We get this a lot at my office. A lot of times employees get accused of, for instance, stealing money or taking information or several different things, but what you really need to look into is why they are accusing you of this or why they may be reducing your hours. You really only have protection if there's some type of protected category, if for instance they're doing it because of your age, if you're 40 or over, or if your race, your sex, something like that. But if it's something like they just don't like you, that's not really against the law. Mississippi has an at-will state where they can hire you and fire you for any reason. That can be reduction, and it's not really fair, but that's just really the only protection under the law right now.
I think Nick brings up the best point, is that Mississippi is an at-will employment state, and they can fire you for any reason, good reason, no reason, bad reason, as long as it's not a discriminatory reason. then I think they're going to be protected. And we'll talk a little bit more about the discriminatory reasons, but I think we've all pretty much heard them: race, color, creed, religion, things like that. But if they are doing it because you're late at work, or because you may be a smart aleck at work, or some other reason, a good reason, or maybe even a bad reason, I think as long as they're doing it and it's legal, they can fire you.
Now, back to at will, is Mississippi unique? Are there other states out there?
Actually, Mississippi is in the majority, and
Okay.
there's only one state, I believe it's Wyoming or Montana, that has protections and doesn't have an at-will station. But every other state, every 49 of the 50 have this at-will status on there, and I think Mississippi was actually the second in the United States to adopt it. But it's pretty clear that that's the majority view, I guess.
Okay, all right. Our next caller is Buddy from Rankin County. Buddy, you can ask your question.
Yes, thank you for taking my call. I own a small business, has about 60, 65 employees, and some of the positions require some manual labor, and we post what those requirements are, and invariably, 1 out of 3 people that we hire, it seems, will have some precondition, medical condition that, as long as it's under control, they can do the work, but invariably, like I said, it'll flare up, and then all of a sudden they have to be out 2 or 3 weeks on medical leave and this and that and the other. Do they have a right to tell us about that and disclose that? Is there anything that we can do? Can we take action against them when this situation keeps popping up?
That's a great question.
Sure. We get that a lot with employers. We do represent a few employers from time to time that, and yes, you can ask potential employers, what kind of medical conditions you can check to see if they can perform the job on there, and make a condition of employment upon them being able to perform the job. But you want to make sure that when you're looking into it, you're not just going after and looking for disability. You want to make sure that they can actually perform the job. And going out on FMLA leave, as you mentioned, is a protected activity. So you can't really discriminate against someone and not hire an employee for because they may take family medical leave in the future. That's highly illegal, so I would definitely advise against that. But if you have someone and you're concerned that they can't perform the job, sure, you can ask those questions to make sure they can perform the job with a reasonable accommodation. You have to make sure that you can make a reasonable accommodation, or if you cannot make a reasonable accommodation for that employee to perform the job. So that's very important.
Let me get this straight. If someone comes in your office and they're disabled and you discriminate against them and don't hire them because of that disability, that would be wrong.
Correct. If you've got 15 or more employees, that's very important.
Okay.
If you've got 15 or more employees and you discriminate against someone because they're disabled, or you think they may have to take family medical leave in the future, both of those are highly illegal.
All right, but if the person works for you for, say, a week or 2 weeks and then is injured, makes a workers' comp claim, you can fire them on the spot.
That's really the quite sad part about Mississippi law right
crazy.
now, is
I was gonna say that.
there really is no protection for filing a workers' comp claim. The Mississippi Supreme Court has had at least 2 occasions to provide that opportunity, and they've declined to. I don't know why, but that's their reasoning.
Far be it from me to criticize the court.
Exactly.
Leave it alone. Our next caller, Joseph from Jackson. You can ask your question, Joseph.
Yes, thank you all for taking my call. I'm enjoying your show. I have two questions. If I were a city worker and I was allotted a 30-minute lunch break, could my boss forbid me from leaving the premises to, let's say, go pay for a bill on my lunch break, on my personal lunch break?
Yes, your boss can limit you to where you go on your lunch break. However, if he does do that, he requires you to be on the premises and be available, he's going to have to pay you for that time when you're on call. So that's something that employer really needs to look at, is if you're wanting that employee to be there, you're going to have to pay him for that time on there. So that is a consideration, but they can terminate you if you leave and they require you to stay there.
What about a cigarette break? Are they entitled to a cigarette break?
Not really. There's nothing that really, growing up, that's one thing. Everyone has their 15-minute break in the morning and 15-minute break in the afternoon, and it really is not protected on there. That's something a lot of employers, it's more of a custom than a law.
Well, can I take a law call break?
Sure. Let's
All
do it
right,
right
break.
here. Yes.
All right, we'll be right back with more of your questions. Tonight we're discussing on-the-job issues. We have attorney Rocky Wilkins and attorney Nick Norris here to take your questions. If you have a question, give us a call at 601-965-7551. Again, the number is 601-965-7551. And we have Jennifer on the line. Jennifer, welcome to Law Call. You can ask your question.
Thank you. I've been away from a company for almost 2 years now, and they're still using my voice and the recording to give the hours of operation. Can they do that?
That's an interesting question.
That's a really interesting question. Does that fall under the employment law?
That really doesn't fall under the employment law, and that could be more of an intellectual property issue. I really have never run into that situation. I would say that you could file a complaint for them profiting from them using your intellectual property, but very honestly, I don't know if that would be it would depend on the situation. It really would depend on the damages on there. I don't know if there's any severe damages, or it sounds like more of a situation where you're just no longer working there and you really just don't like them using your voice, which could be very valid, and you could hire an attorney to get an injunction for that, I assume.
Well, there's a claim for misappropriation of someone's likeness, but what it sounds like, Jennifer, is that you gave them permission to use your name or your likeness or your voice, and then you left, and now you, like Nick was saying, you don't really like that. I would think that you probably don't have a claim, but if you want to give me a call Monday, I could probably find out for sure.
Yeah, it's kind of similar to working in television news.
Correct.
Absolutely.
Exactly.
You're gone from the station, and you're still part of those story packages and maybe promotions.
Exactly.
And I bet there's some fine print somewhere that she signed that said they could use her likeness or voice after the
forever, yes.
All right, our next caller is Paul from Leake County. Welcome to Law Call, Paul. You can ask your question.
Yeah, it's Paula.
Paula,
Hey, Paula.
I'm sorry, I didn't see the A there. I'm sorry, Paula.
That's all right. I was wondering if for some reason you had a professional license and the business was doing something that could affect your license, you brought it to their attention, and their response was they could not correct it right now. If for some reason you quit and was not able to find a job, could you get benefits, or did you have any other type of recourse?
That is an interesting question. We do from time to time have employees that have a license, for instance, like a nursing license, or if it's a doctor or real estate agent or whatever it is, and they're forced to do something that's beyond their license. And what first you need to look into is whether that going outside of your license is a crime. And if it is a crime, then you can complain to your employer, and if they still refuse to do it and you essentially are forced to resign to comply under your license, you could have a claim for wrongful termination on there, and there are damages for your lost wages. They could be forced to reinstate you and comply with the license. They could be required to pay future wages and attorney's fees as well.
But practically speaking, if you know somebody's committing a crime at your employment and you report it, you're going to think you're going to get fired for that.
Exactly.
And so because of that, there are some remedies in the law. One that comes to mind is a qui tam or a qui tam action, where you can actually, if you relate that criminal act or you tell on the business, you can join the government and actually sue the business and get triple damages, because they know that if you're a whistleblower and you're going to report on your boss, it's going to be real uncomfortable for you. So they have to give you some sort of extra incentive to do that, because you're probably going to get fired and you're probably going to go through a lot if you tell on your boss.
Sure, it's very important on those qui tam claims, and one thing you want to look at if you think you may have one of those claims is whether using that license defrauds the government. And if that does, then yes, you could have a qui tam claim.
Okay.
All right, our next caller is Willie from Jackson. Welcome to Law Call, Willie, and you can ask your question.
Yes, I want to know, if you've been with a company 4 to 5 years and they haven't given you a raise, can they legally do that?
Yes, that's really
More bad news.
More bad news. As an employment lawyer, I really have to hand out a tremendous amount of bad news, very frankly. There's not a whole lot of laws that protect employees. Mississippi really only has one wrongful termination law that the Supreme Court created, and everything else is federal. So really, there's no requirement that they pay you any certain rate or that they give you a raise ever so often. The only thing they're really required to do as part of pay is to pay you minimum wage and make sure if you are not exempt to be paid overtime.
Let's talk just a little bit about overtime claims, because I know that you've brought some.
Can we talk about it just a second?
Sure,
All
absolutely.
right, so we can go.
You're the
Still
boss.
going to overtime?
You're the boss.
All right, it's time for us to take a quick break, and we'll be right back with more of your questions. If you have additional questions for our guest attorney, Nick Norris, you can contact him in Jackson at 601-968-0000. Rocky Wilkins can be reached at the Rocky Wilkins Law Firm in Jackson, 601-948-6888. And Tim Porter can be contacted at the Porter and Maloof Law Firm in Jackson, and his number is 601-957-1173. And before we take our next call, I'm going to let Rocky pick back up. We were going into a little discussion about overtime.
We're going to talk about overtime,
Okay.
and Nick's firm has done a lot of overtime cases.
Right.
And why don't you explain to us a little bit about how an employee can be working for, say, a teacher's group or a school and be accumulating overtime and not get paid for it? I mean, how does that happen?
That happens a lot of times with teachers' assistants, janitors, bus drivers. We've represented quite a bit of school employees over the years, and a lot of times it happens through illegal comp time policies where these employers adopt them, don't really follow the rules regarding them, and that really causes a lot of problems, or just not paying. Several years ago we sued a good bit of the state where several school districts weren't paying employees overtime. They were just having to mark down 8 hours every day.
What about like extracurricular activities that they force them to go to? You see a lot of teachers at
Sure.
football games and working the concession stands. I mean, if they're working, are they supposed to be writing that time down?
If they're working, they're supposed to be writing that time down, and they're supposed to get paid. One of the things you want to be careful of in those situations is where they have volunteer and non-volunteer. So if you're volunteering, that may not be something that you get paid for. But if you're not volunteering, you're forced to be there, you should be paid for it.
Okay.
Okay, very well. Our next caller, Jean from Rankin County, is on the line. Jean, you can ask your question.
Yes, I was told that there needed to be more testosterone in our office, so instead of keeping me for the office manager, they hired a man. Is that legal?
Wow, sexual harassment. Gene, that's a great question, and I'm glad we got Nick. Let's
Right,
talk about
that
it.
seems like very direct evidence of sex discrimination, very frankly, where they're essentially saying testosterone is something it's linked into sex, and where they're saying this is the only reason we're terminating you and we're replacing you with a male. That looks to be pretty direct evidence of sex discrimination to me. That's highly illegal. The only situation where it's not illegal is if they have less than 15 employees. And if they've got 15 or more, that's clearly illegal. And what you need to do is immediately go to the EEOC, file a charge of discrimination for sex discrimination. You have to do that within 180 days of when that comment was made. So you need to do that immediately.
Very
Don't wait
short
on it.
time period.
Yes.
Very short.
What about last year there was a restaurant that had forwarded an email from an employee to a manager
Oh, yes.
with some racial overtones. What should an employee do if they get an unwanted racial or sexual email?
That's very important, and we get that a lot at the office. And what you need to do, a lot of corporations have discrimination policies. What you need to do is report it to HR. Report it, if they don't have an HR, report it to management. You need to report it every time, and if management doesn't do anything about that hostile work environment, you need to go to the EEOC and make a complaint on it. It's something you need to go to management first, give them the opportunity to correct the issue, but if they don't correct it, then go to the EEOC and contact a lawyer. That's very important.
All right, our next caller, Bob from Crystal Springs. Welcome to the Law Call, Bob, and you can ask your question.
Yes, sir. Say you've been working for a company, they've been paying you by a paycheck with check stub, and all of a sudden they decide to start using a bank card, like a debit card, but every time you use this debit card, they take $2.50 of your original paycheck amount and your paycheck out every time you use it. So if you use it 4 or 5 times, it could range anywhere from $10 to $15 that you're not getting of your own paycheck.
That's an interesting question. I've actually never run into that situation, but I could tell you where it does run against the law is if you're an employee and, for instance, you get paid overtime and that deduction causes you to get less overtime than what you should have received. That would be a clear violation under the Fair Labor Standards Act for the employer not paying you completely for that overtime on there where you're not receiving it, and especially if that $2 goes to back to the employer. I think that would be highly illegal. If it goes through another entity, there could be some question on it, but if it goes back to the employer and the employer is charging that $2, that's definitely illegal.
All right, Nick Norris.
Thank you.
Fine job. How many questions there? Yeah, you did a really good job. You helped a lot
Very
of
good.
people.
Thank you,
there.
thank you.
Thank you,
Have
Nick.
you back here, and we'll see you. I think you may be coming around back next week.
That's right.
All right, and
The
hopefully
truth
you'll.
about trial lawyers.
All right, here next
wait.
week, 6:30. We will be right back here discussing some of the misconceptions and all the details and all the information you know. Wait a minute, where am I? I'm getting lost here. Lost
The
my
truth
script here
about
about
trial
trial
lawyers.
lawyers. Just keep it simple. Truth about trial lawyers, 6:30 right here next Saturday. Good night, everyone.